Hear first from the defendant, and then I will hear from the Commonwealth. Mr. Reddington.
Thank you, Judge. Misconduct, and I feel that the court should grant the motion for mistrial.
All right, thank you. Commonwealth? And with God. All right. Now we're getting a little closer to problematic area. Then my thought is I'm going to bring the jury back in. I'm going to give them that instruction, and I'm going to send them home.
Before we jump into this courtroom exchange, pay close attention, because what happens here is not a routine objection. It is a direct challenge to whether the jury may have been exposed to information the defense says could unfairly influence its decision. We're in the trial of Conwell versus Lindsay Clancy, and the defense is about to ask for one of the most dramatic remedies available during a trial, a mistrial. The issue: references to Catholicism, mortal sin, heaven, and the moral consequences surrounding the defendant's conduct. The defense argues this subject had already come up before, that objections had been raised, and that the repeated references could prejudice the jury. The prosecution sees it very differently, arguing that the witness was explaining his reasoning and that the defendant's understanding of moral wrongfulness was relevant to the evaluation being discussed. And now the judge has to walk a very narrow line: protect the defendant's right to a fair trial while deciding whether the problem can actually be fixed with an instruction to the jury. The big question is this: can a judge simply tell jurors to disregard something they have already heard and trust that they can completely put it out of their minds? Stay with this one, because the judge's response is about to reveal exactly where that line is drawn.
This court is back in session. Please be seated.
Your Honor, for the purpose of the record, we return back to the trial of Commonwealth versus Lindsay Clancy. All parties are present, excluding the jury.
All right. After the following sidebar conference, I think the defendant made a motion. I'm going to allow argument in regards to the motion. I'll hear first from the defendant, and then I will hear from the Commonwealth. Mr. Reddington.
Thank you, Judge. Your Honor, this has been obviously a long trial and a lot of work on the part of everybody involved, from the court to the staff to the prosecutors to myself, and needless to say, the strain on Lindsay Clancy. I have to move for a mistrial, reluctantly. The reason is that this is intentional misconduct on the part of the prosecution. You know that this whole idea of injecting Roman Catholic faith, the concept of mortal sin, into this trial occurred, I don't even remember now, about a week ago, and I objected, but before I could get the objection out, Your Honor had us at the sidebar at the same time, and very forcefully, in my opinion, indicated to the jurors that they should not consider that to any degree. At the time, I put on record the fact that I did not feel that I felt that the court's instructions were sufficient. They were forceful. They were right on point. And we moved forward without a motion for a mistrial. I made a tactical decision. But unfortunately, at this point, it's a concern I have, because this is just over the top. It's the same thing again, talking about religion, talking about heaven, talking about killing people and the impact or the effect that it would have on Lindsay as well as her children. The fact that this is not the first time that it occurred during the trial, and the prosecution has previously brought up the concept of mortal sin, based on your ruling in the past, in conjunction with the fact that they brought it up again, I believe it was...
This is the defense drawing a very important distinction. The request for a mistrial is not simply because the attorney dislikes the testimony. The argument is that repeated references to religion and moral concepts could have an unfair impact on the jury, particularly because the defense says the subject had already been addressed and the judge had previously instructed jurors not to consider it. The defense is also emphasizing that it made a tactical decision earlier not to seek a mistrial, but now believes the issue has happened again and crossed the line. That matters because the judge is not just deciding whether the testimony was uncomfortable or controversial. The real question is whether the alleged problem is serious enough that the trial cannot fairly continue. And remember, the defense is specifically alleging intentional misconduct, while the prosecution is about to argue that there was no intentional attempt to inject religion into the case. So now we get competing versions of what actually happened, and why. Do you think repeated testimony on the same subject changes the seriousness of the mistake, even if the witness wasn't deliberately trying to influence the jury?
I believe it was intentional misconduct, and I feel that the court should grant the motion for mistrial.
All right, thank you. Commonwealth?
Thank you, Your Honor. The question I asked the witness did not ask for any testimony about religion, about Catholicism, about mortal sins or anything like that. And the slide is still up on the screen. There's nothing on the slide about Catholicism, about mortal sins, about any of that. The witness was explaining his reasoning. I don't think it was intentional on part of the witness either. If we look at his interview of Ms. Clancy, one of the things that this witness has to do is determine whether the defendant knew the wrongfulness of her conduct. And that can be either that it was criminally wrong or morally wrong. And he explored that with her in the interview and asked her about whether she knew it was legally wrong, and she said she had no concept of legal consequences. And then he went on to ask her about moral wrongfulness and about her religion and whether she knew it was morally wrong, and she did say that she had knowledge that suicide was considered sinful. So I believe that's where the witness was going in trying to explain his reasoning. I don't think he was intentionally trying to inflame the jury or cause an issue in this case. I know I certainly wasn't, because I didn't ask a question about her religion or a question that would invoke that kind of response. I asked him to explain what was on the slides, and that's not on the slides. So there was no intentional conduct by the Commonwealth. That was not where I intended to go with this questioning, and I don't think that the witness intended to do any harm either. He was just explaining his rationale. So I would ask that the jury be instructed to disregard the answer, and I can speak to the witness and tell him not to talk about that reasoning for behind his thoughts, that he can testify about his conclusions.
Now the prosecution is offering the judge a potential middle ground. Their position is essentially, the question itself did not ask about religion, the presentation slide did not contain religious material, and the witness was explaining how he reached his conclusions. According to the Commonwealth, the discussion of moral wrongfulness came from the witness's understanding of the defendant's interview, not from an intentional effort by the prosecution to influence the jury. And notice the proposed remedy. Instead of throwing out the entire trial, the prosecution suggests allowing the witness to continue giving his conclusions while preventing him from going into the religious reasoning behind those conclusions. That is a significant distinction. The courtroom isn't deciding whether every statement made by a witness is automatically admissible simply because the witness believes it is relevant. The judge still controls what information the jury gets to consider. But the judge isn't completely satisfied yet. A specific statement is now coming back into focus, one involving God, heaven, and the children. And that appears to push this issue closer to the boundary the judge has been trying to protect.
His conclusions, but to leave that portion of his reasoning out of his testimony.
Well, here's a concern I have, is what the witness did say in regards to go to God, baby, go to God. That was statements that had been made in evidence already. And then he indicated that was part of her expectation, that she and the children would be together in heaven with God. All right. Now we're getting a little closer to problematic area. Then he testified she was raised as a Catholic. And as I understand Catholic considerations, that's not necessarily what happens. How is any of that proper at this point? But it was not, well, I'm not going to declare a mistrial at this time. What I am going to do is I'm going to bring the jury in. I'm going to tell them to disregard it. I'm going to tell them that's an inappropriate area of inquiry, and that this witness's understanding of Catholic dogma or Catholic teaching is irrelevant. There's no evidence of his background or training or having been to the seminary or any of that. And so I think, and that's where he ejected that. And so I am giving that, but the Commonwealth, I'm going to strongly, and perhaps the strongest language, talk to him and let him know that he can't go into that. And then my thought is, I'm going to bring the jury back in. I'm going to give them that instruction, and I'm going to send them home. I don't want them leaving here today with the last thing they heard was a discussion about this witness's understanding of the Catholic teaching. That's not the last thing they're going to hear. And so my thought is that, as best I can, is to address that and minimize.
And there is the ruling. The judge denies the motion for a mistrial at this point. But that does not mean the judge is brushing the issue aside. Quite the opposite. The judge identifies the religious discussion as an inappropriate area of inquiry, specifically says the witness's understanding of Catholic teaching is irrelevant, and plans to instruct the jury to disregard that testimony. This is also where the judge explains the practical concern. The jury should not leave for the day with the religious discussion being the final thing occupying their minds. So the court is trying to minimize what the judge describes as potential damage or prejudice while relying on the jury to follow the instructions. That is a crucial moment in the transcript. The judge is essentially saying, the trial continues, but this line of testimony stops here. The Commonwealth is also being given time to speak with the witness before testimony resumes. Do you think that's enough to cure the problem? Or once jurors hear something potentially influential, is it unrealistic to expect them to simply erase it from their memory? Let us know what you think.
Minimize the damage or prejudice, because I do presume that this jury will be able to follow those instructions. And so that would be my thought. We'll come back. That will give the Commonwealth plenty of time to talk to this witness, to let him know the areas that he should and should not go into. And then we can come back tomorrow and we can resume his direct examination and cross-examination. All right, so that would be my thought. We'll bring the jury in. I'll give them that instruction, and then we will recess until tomorrow. Okay?
Your Honor, and just for the record, could I note an objection?
Sure, absolutely. All right, so we ready for the jury? Yeah.
Court, all rise. Jurors enter. This court's now in session. Please be seated.
Your Honor, for the purpose of the record, we return back to the trial. Commonwealth versus Lindsay Clancy. All parties are present, including the defendant and including the 18 jurors.
All right. Well, members of the jury, just before we broke, there was some testimony from that last witness. And I just want to give you some instructions in regards to that testimony. And I just wanted to let the religion that the defendant was raised with is absolutely an inappropriate area of testimony. It is to be stricken. It is not to be considered. I can't be any more clear of that. It cannot be considered. Secondly, the witness's understanding of Catholic teachings and considerations, again, is immaterial, it's irrelevant, it is to be disregarded based on that testimony. All right? And so, because we had a little bit of a delay due to this, what I'm going to do is I'm going to excuse you until tomorrow. All right? And so the thought is we'll come in, we'll finish up with this witness, I believe the Commonwealth has another witness at that point, and then we'll talk about where we go. I apologize for any kind of confusion or delay, but I just wanted to make sure you had those instructions with you when you left here today. All right? So, I'm sorry, so I'll see you tomorrow. Thank you.
Court, all rise. Jurors, kindly close your notebooks. Place them on the chairs. This way, please.
So, let's bring the courtroom sequence together. The defense asked for a mistrial, arguing that references to Catholicism, mortal sin, heaven, and related moral concepts had been improperly introduced and could prejudice the jury. The Commonwealth disputed the allegation of intentional misconduct, explaining that the witness was attempting to describe his reasoning concerning the defendant's understanding of moral and legal wrongfulness. The judge ultimately did not grant the mistrial at this stage. Instead, the court took a narrower corrective approach. The jury was explicitly instructed that the religious background and the witness's understanding of Catholic teaching were inappropriate, irrelevant, and not to be considered. The judge then recessed the jury until the following day, giving the Commonwealth time to address the boundaries of the witness's testimony before the examination continued. The broader takeaway is about courtroom control and fairness. When potentially improper testimony reaches a jury, the court must decide whether the problem requires ending the trial or whether a clear instruction and corrective measures can sufficiently address it. There was no final verdict or ultimate resolution of the entire case in this excerpt, so the significance here is specifically the judge's handling of the mistrial request and the disputed testimony. If you found this case as shocking as we did, make sure to hit that like button. Share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.